All right, welcome back to the Judicial Proceedings Committee. Today's Thursday, January 29th, 2026. We have 5 bills on the docket, and we're going to start off. Senator Simonaire. Is Senator Simonaire? Kara's going to get it? All right. We'll come on up and present Senate Bill 42, and then after that, Senate Bill 250.
Thank you, Mr. Chair, members of the committee. Kara Contino on behalf of Senator Simonaire for Senate Bill 42. So some organizations have made it their mission to give thousands of unclaimed veterans the dignity and honor they deserve by providing a proper final disposition of their remains. In the Courts and Judicial Proceedings article, specifically 5-642, veteran service organizations are not civilly liable if they act in good faith when transferring unclaimed veterans' remains. In 2024, as you know, the General Assembly passed laws that expanded the types of decomposition of bodies under the leadership of your Vice Chair. This bill would simply update 5-642 to include the same type of civil protections for the transfer of those additional types of decomposed remains. That's essentially the bill, and I'll ask for your favorable consideration.
Appreciate that. Thank you very much. Interesting topic here. All right, that'll conclude the hearing for Senate Bill 42. We'll now move on to Senate Bill 250.
Thank you again, Kara Contino on behalf of Senator Simonaire, presenting Senate Bill 250. The senator coordinated closely with the Maryland Judiciary, the Uniform Law Commission, and the Maryland Bar Association on this bill. This bill would revise our laws as it pertains to when people effectively die simultaneously, whether instantly or within a short period of time. This bill incorporates the revisions adopted by the Uniform Law Commission when it comes to simultaneous death. Back in the 1940s, the Uniform Simultaneous Death Act was created and nearly every state enacted it. Since then, it has been updated a few times in the 90s, and this bill incorporates those changes. It primarily deals with people dying within a short period of time and how to handle it efficiently. It's called the 120-hour rule and treats individuals who have died within 120 hours of each other without a will as dying simultaneously. This is widely accepted among states, and it would be a tremendous improvement to our laws and help our constituents. You will hear from some constituents today that will share their specific examples, and we also brought in experts from the Uniform Law Commission. And additionally, Senator West is also here as your own expert. With that, I'll leave it at that, and I am happy to answer any questions. I also have them answer any questions if need be.
Excellent. Thank you very much. I thought Senator West was just trying to boss hog his way into being next on the list, but you're here for as an expert. All right. All right. Well, we've got in person, so we'll bring up your panel then. So is Stephen Lightis, and then Julia Cage, and then Joanna Bloom. And then, then we'll be joined with Mr. Orzeski, who is joining us remotely. Come on up. Welcome.
Good afternoon, Chairman Smith, Vice Chair Wallstreicher, and members of the committee. Thank you for the opportunity to speak today in favor of Senate Bill 250, the Maryland Uniform Simultaneous Death Act. My name is Stephen Lightis. I'm one of Maryland's commissioners to the Uniform Law Commission, which is the organization that drafted the act. This act is an update of the uniform state law that Maryland adopted over 50 years ago, the Uniform Simultaneous Death Act by the same name. This legislation addresses an inequity that can occur when two individuals who own property together die in a common accident, such as a car wreck or a plane crash, and it resolves issues that cause the heirs great stress and pain following the loss of their loved ones. My co-panelists will explain why the act is needed and the key features of the act that resolve an important problem facing Maryland families. My role here is to introduce the organization behind the hard work of drafting this and other uniform acts. I'm a member of the Maryland Commission on Uniform State Laws, and I serve as a commissioner in the Maryland delegation for the Uniform Law Commission. The Uniform Law Commission is a 134-year-old state-sponsored organization, a group of volunteer attorneys that provides states with nonpartisan, well-conceived, and well-drafted legislation that brings clarity and stability to critical areas of state statutory law. The study and drafting process is open and inclusive. It encourages participation by persons and stakeholder organizations with a wide variety of perspectives and subject matter expertise, with the goal of creating the highest quality draft legislation possible. A uniform act like this one goes through several years-long process. It starts when someone proposes an idea for a uniform law, and if the idea is accepted by the ULC, it appoints a study committee to examine the need for an act. If the committee recommends a drafting committee, then the ULC will appoint a drafting committee that then spends 2 years, and there's a reason for that. There's a cycle of meetings and drafts that circulate. And then after 2 years, they typically reach the final act.
Excellent.
Finally, every July, the entire ULC meets in Bonk, if you will, over 300 commissioners from every state,
Mr. Elias.
D.C.
The time's expired. If you could just very quickly conclude, and then you'll have an opportunity for question and answer. But the 2 minutes has expired.
Okay. All right. Well, thank you for your time. I will yield to the subject matter, folks.
Excellent. Thank you. Whoever would like to come next, we generally invite our guest up to the podium if you can make it. Thanks.
Good afternoon, Chairman Smith and members of the committee. My name is Julia Cage. I'm a constituent of Anne Arundel County, and I am in strong support of Senate Bill 250. Maryland is currently an outlier in a state law, and by adopting the 120-hour survival rule included in the USDA, we will join 44 other states in fixing a technicality that currently invites litigation based on survival by the minute, at the expense of common sense and the intent of the deceased. While my friend Joanna Bloom will share her personal toll that this outdated law has taken on her family after a tragic fire in Annapolis, her story highlights a systemic vulnerability for all Marylanders. Currently, if spouse A survives spouse B by minutes, a legal windfall may occur for spouse A's heirs. Assets are at risk of being diverted away from spouse B's children or heirs and into a secondary estate to the heirs of spouse A, who is also deceased. This may trigger a redundant double probate, wasting the court's time and draining estates with back-to-back fees. This situation forces heirs to litigate the exact second of death through expensive expert testimony. A forensic technicality risks disinheriting a person's own children, diverting a lifetime of assets to a different family tree entirely. This is a critical issue for Maryland families. 2/3 of divorced Americans remarry, and only 30 to 40% of Americans have a will. Without the 120-hour legal circuit breaker in the USDA, any family tragedy becomes a forensic race. We should not be litigating tragedies by the minute. We should be ensuring the assets of an estate are transferred equitably and according to a natural line of succession. SB 250 ensures that the Maryland law honors the presumed intent of the deceased and the natural line of succession while streamlining probate procedures. It clarifies the 120-hour standard, which 44 other states have already implemented through the USDA Uniform Probate Code or their own independent state laws. Please support Senate Bill 250 to ensure that a few minutes in the aftermath of a tragedy do not result in a prolonged legal and financial stress for descendants in the courts. Thank you.
Hi. May I start? Okay, great. Thank you so much for having us here today. Chair Smith and members of the committee, my name is Joanna Bloom, and I want to thank you for your time and for this opportunity to voice my strong support for Senate Bill 250. I'm currently managing an estate that involves the Maryland USDA. Last February, my father and his wife were killed in a house fire in Annapolis. By the time the first responders arrived at the scene, the whole house was engulfed in flames, and tragically, both my father and his wife died as a result. My father had made a will in 1992, which I believe was also lost in the fire, and my siblings and I have spent the last year doing countless hours of research and going through the probate process to determine the fate of my father's estate. It is my belief that the intent of the Maryland law was to avoid the situation that I'm now in, which includes prolonged estate management with a significant associated time, expense, and administrative burden, extensive expenses related to understanding our legal position and outcomes and options, the inability to unilaterally preserve jointly owned property because it's unclear who has legal authority, and being left with little option but to pursue litigation that will require recreating the second-by-second details of both my father and his wife's deaths, which is exactly what I think this law originally sought to avoid. I'm tired, and I wish this was easier. So I'm testifying, in support of Senate Bill 250 today to help the stress and strain that my family has endured this past year, and in the hopes that it'll bring clarity and peace to other Maryland families. Thanks for your time and consideration.
Well, thank the panel for your testimony. Ms. Bloom, sorry, our condolences, and thank you for willing to, I say this a lot, too often in this committee, but it takes a lot to come up here, take time away from your, your family and your work, and it's not easy to testify in front of a committee, but also it's even more difficult when you're testifying on something so sensitive and so recent and so personal. So thank you for doing so to help us make better policy. All right, we'll open it up for questions from the committee if anyone has any. For anyone? We've got an expert here. Virtual. Virtual. Oh, no, okay, hold on. All right, well then, we'll go on to Mr. Orzeski, who's joining us virtually. Ben, welcome.
Thank you. My name is Ben Orzeski. I'm Chief Counsel at the Uniform Law Commission. I appreciate the opportunity to testify here, Chairman Smith, and to members of the committee. Ms. Bloom's testimony was compelling. The law that the Uniform Law Commission has drafted to deal with this situation was updated in 1993, but Maryland never adopted the updated version. And by adopting the updated version, you can avoid other families having to go through similar situation as Ms. Bloom. It's best illustrated with two simple examples. The current Maryland law only applies to the situation where a couple dies in undetermined order in a common accident, and it's impossible to determine who dies first. And in that situation, it provides a simple rule that for the purpose of inheriting property from the decedents, each person is deemed to have outlived the other, and their own heirs will inherit. What this legislation will do is expand the application of that rule. So it not only applies when the order of death can't be determined, it also applies when the order of death is in close proximity, within 120 hours. So if one spouse dies in a fire and another dies in the ambulance on the way to the hospital, the result will be the same. Each family will share equally in their property, in their inherited property, rather than the spouse who survived by a few moments first inheriting everything and then property being passed to that spouse's family. So it's a common sense reform. I'll be respectful of the committee's time. I'm happy to take questions, but I don't think there's anybody opposed to this, and so we ask for your support.
You're correct. There's no one signed up in opposition, but Senator Sidnor has a question.
Thank you very much for the gentleman from the Uniform Code. Who's he? All right, the gentleman on the screen. I'm curious because when I first looked at the legislation, I thought one thing, and then I heard the testimony from two women who had testified that this seems to be for situations, I guess, where maybe a husband or wife have had taken on another spouse, and then you have multiple families. Is that when this usually comes into play?
Sometimes. It's not the only situation, Senator. But certainly if a husband and wife have children together jointly, then this issue doesn't come in. It's not an issue because they'll inherit. That's correct.
Right. So this will come into play if the husband, the deceased husband or the deceased wife maybe had children outside of that particular relationship. Generally speaking, is that correct?
No, sir. Not only. It also would come into play if spouses don't have any children, if they've never had children, because each of their families, their siblings or their parents would then inherit from them. And this law would say that their families would split that property equally, despite the fact there were no children.
Okay. Thank you.
Excellent. Further questions from the committee? All right. Seeing none, thank you all very much. Thank you. Thanks. All right. We're now going to go on to Senator Love with Senate Bill 251.
Thank you, Chair. Yes?
Max is boarding, so he's going to try and be on.
Okay. Okay. Thank you, Mr. Chair. I believe I have some witnesses who are virtual. one of whom is actually boarding a plane right now, so he's going to try to be on, but we're not sure. So with that, I'll start. Good afternoon, everyone. Thanks for sticking in with us. Really appreciate it. That was a great briefing. Many thanks to the chair and to committee counsel and committee manager for putting that together. And we're turning here to Senate Bill 251. I am Sarah Love, here to present it. This bill may seem familiar to you, as we have had anti-SLAPP legislation before, but it is not the same. This is, as coincidentally, we just heard from the Uniform Law Commission. This is another Uniform Law Commission bill. This is the Uniform Public Expression Protection Act, or UPEPA. So I know we're all familiar with the concept of SLAPP, but just to reiterate, SLAPP means strategic lawsuit against public participation. The goal of a SLAPP lawsuit is to entangle the defendant in expensive litigation, stifling the defendant's ability to engage in constitutionally protected speech. So SB 251 is designed to quickly challenge and dismiss a SLAPP suit, a suit without merit. I shouldn't say a SLAPP suit because that's redundant, a SLAPP without merit. So to be clear, it's dismissing expeditiously a suit without merit, allowing those suits with merit to continue. Maryland's SLAPP law, anti-SLAPP law, while very good when it was enacted in the early 2000s, is now outdated, and we receive a D for protecting speech. So updating this law is really important in protecting First Amendment rights and activities. Last year, we heard from a number of people about different examples of SLAPPs. Senator Hettleman talked about Baltimore residents who had organized against a bar coming in, and they were sued. Tom Cole testified about a woman who ran a blog, and she commented on a petition that was being run by someone else, and that blogger was sued, and then Tom was subsequently sued. That suit has been going on for 5 years, and the woman who wrote the blog has actually won twice at trial, but it's still going on. Judge O'Malley talked about a Kent County teacher who had alerted the Navy about some racist posts, and then that teacher was sued. And today, you'll hear from a Harford County resident. I'm sorry that our Harford County senator isn't here to hear her constituent, but we'll hear about her experience with SLAPP. So these suits are harmful, and our current law does not protect our residents from them. So as I mentioned, this year we are taking a different approach. The bill before you is a uniform act written and supported by the Uniform Law Commission. UPEPA has been enacted in 15 states, red, blue, and purple. Some examples: Kentucky, Hawaii, Michigan, Montana, Ohio, Pennsylvania, Utah. It's also been introduced in another 9 states this year. It was just introduced in South Dakota this week. The Uniform Act also has supports across different organizations, from the ACLU to the National Right to Life Committee, the Freedom of the Press Foundation, the International Association of Better Business Bureaus, the Motion Picture Association, and my favorite, the Comic Book Legal Defense Fund. So I want to walk you through this structure, and bear with me, I'm going to get a little weedy. But the way this starts is a company or an individual files a lawsuit against someone, usually claiming defamation. It could also be intentional infliction of emotional distress, usually over some criticism that that individual has given. So the individual who is sued says, wait a minute, you're just suing me because I criticized you, because I exercised my freedom of speech. So that individual files a motion with the court saying this is a SLAPP. So upon the filing of that motion, all the proceedings are stayed, and there are a few exceptions laid out in the bill. So at that point, the bill sets up 3 phases. In the first phase, the court effectively decides, does the act apply? So the burden is on the moving party, the person who was originally slapped, the defendant in the slap suit, to show that the original suit implicates their right to free speech, petition, and association. If the moving party fails to do that, their slap motion is denied and the original suit goes on. So if they succeed in that, the responding party, so that was the original person or company that sued, the slapper, if you will, they can show that the cause of action falls into one of three exceptions. If they succeed, slap motion denied, original suit proceeds. If they do not succeed, then the act applies. The court goes on to step 2. So in the second phase, the court determines if the responding party, the original slapper, has a viable cause of action on its face. So in this phase, the respondent has to show a prima facie case to each essential element. Basically, if you show on its face that your claim has merit, you can go forward. If they did not do this, then the motion is granted and the case ends. But if they did show a prima facie case, then the court moves on to the third phase. Are you with me so far? Everybody good? Okay. In the third phase, the court determines if the respondent has a legally viable case. So here the burden shifts back to the moving party, to the person who was slapped, to show that the respondent failed to state a cause of action upon which relief can be granted. Those of us lawyers know that's the motion to dismiss standard. Or that there's no genuine issue of material of fact and they are entitled to judgment as a matter of law. Summary judgment standard. If they show that, motion granted, case ends. So I know that was a lot of legal technology, but I wanted to walk you through this uniform law and uniform bill. And with that, I'll turn it over to my panel. I have Caitlin Wolf from the Uniform Law Commission. We may hopefully have Max Mishkin, an attorney who has represented clients who have been slapped. We have Rebecca Snyder from the Maryland D.C. Press. And we also have Stephanie Flash, a Harford County resident who was slapped. And Mr. Chair, we can take it in any order that you would like.
Yeah, that would be Max. Oh, and there he is.
There he is. Max.
Max, you're up.
Good afternoon. Thank you. And I apologize that I won't be able to stick around for long for questioning, but thank you, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Max Mishkin. I'm an attorney in the Media and Entertainment Law Group at Ballard Spahr, and I appreciate the opportunity to speak today in support of Senate Bill 251. I'd like to touch on just a few points from my written testimony about how this uniform bill would vastly improve on our outdated and ineffective current anti-SLAPP law, and why that's an important step forward for our state. First, the changes that Senate Bill 251 would provide have a proven track record. You can look at anti-SLAPP laws across the country, in particular the ones that have adopted the uniform UPEPA law, and you'll see that state after state agrees that when someone sues over speech on a matter of public concern, the person suing should have to show early on that case has merit. Likewise, you'll see the consensus that when a plaintiff brings a meritless SLAPP lawsuit and loses, the plaintiff should have to pay the defendant's attorney's fees. These are the kinds of provisions that make an anti-SLAPP law effective and reliable. Second, a stronger anti-SLAPP law helps organizations of all kinds and people of every political leaning. I've seen that firsthand as my colleagues at Ballard Spahr and I have filed anti-SLAPP motions for conservative anti-abortion filmmakers being sued by a Democratic state court judge and for a national Democratic advocacy group in a lawsuit brought by a GOP megadonor. In just the past few years, we've asserted anti-SLAPP provisions against an iconic Republican sheriff and against a rising star Democratic lieutenant governor. Anti-SLAPP laws are not a partisan issue. Third, and finally, now is the time to put these protections in place. Libel bullies bring meritless lawsuits every day because they feel confident that even if they lose the case, they can still win the fight by making defendants spend time and money and think twice before expressing themselves again. Senate Bill 251 is the right bill, this uniform bill, to take on this growing threat to free speech. I encourage you to report it favorably. Thank you again for the opportunity to testify today, and apologies again for not being able to stick around.
Yeah, no worries. Thanks a lot, Max. I know you're about to board a plane, so we appreciate you making the accommodation. Real tough question for you, though. Who do you root for during the Harvard-Yale game?
As a former tuba player in the Harvard University band, I will always root for Harvard because I know all the fight songs.
That's an honest answer. That's an honest answer. All right.
Thank
Go
you.
ahead. Enjoy your flight. Be safe. Thank you
Thank
for
you.
testifying.
I appreciate it. Thank you so much.
All right. We are now going to go to. Do you have another preference? All right, let's go to Ms. Flash.
Hello, good evening. My name is Stephanie Flash, and I am in favor of Senate Bill 251. Never did I imagine that when I engaged in a bagel shop conversation with my friend Beth Pajoli, that just to create a petition and encourage public participation in Harford County land use planning, that I would be a defendant in a lawsuit 1 month later because of my efforts. And as a prior military officer and member of several community advocacy groups and a volunteer of community organizations, I really understand the value in participating in county public hearings and following local government policies and being able to communicate with our elected officials for my community. Beth Pajoli and I started a petition in March of 2016 that informed our neighbors of a possible expansion of our development envelope approximately 5 miles from my house in the Fallston area. And it was a proposal in the Harford Next, Harford County's master land use plan legislation. And the petition only encouraged the public to voice their opinions on possible impacts on infrastructure and the precedent for agricultural zone properties in Harford County. So I felt strongly about providing an informative petition after speaking with a couple of our county councilmen who mentioned that citizens just weren't reaching out and contacting them for the expansion that was proposed, which led them to assume that this minor expansion was okay with our community. Our goal was only to ensure that citizens understood what that expansion meant for our community. And so Beth and I were amazed at how quickly our neighbors responded with the feedback, I don't support it. The expansion, we had over 1,000 electronic signatures. And so Beth and I scheduled meetings with our district's Councilman Joe Woods at the time and another county executive, Barry Glassman, and Mr. Brad Killian, the Director of Planning and Zoning. And we shared our thoughts on Harford Next and provided a printed copy of the petition. At the meetings with the local elected officials, I was discouraged to hear that the petition's feedback and comments being critically scrutinized for the credibility instead of being more about the feedback given by the public. And so I was a little disturbed when an official mentioned that the developer was very interested to hear who was behind the petition. But overall, we are pleased that we are increasing public participation and hopefully driving citizens to participate. And what was needed by the county council and our county executive.
Ms. Flash.
Yeah.
Sorry, I'm sorry, the time has expired. If you could just briefly conclude.
Oh, okay. It's just the SLAP suit is definitely needed in our area to make sure that public participation is still encouraged and a strong anti-SLAP law is needed in Maryland.
Excellent. Thank you very much for your testimony. We'll now move on to Ms. Wolf.
Thank you, Chairman Smith, members of the committee. It's a pleasure to be with you today. My name is Caitlin Wolf, and I'm testifying in support of the bill on behalf of the Uniform Law Commission. As you've heard, this bill has been enacted into law in a number of states, 15 already, in all pockets of the country. As Senator Love mentioned, very diverse states as well with different communities. But I think what's gotten this bill so much positive attention and support is the fact that it does protect everybody. I want to remind the committee that these SLAP suits can occur in a variety of circumstances. It's the parent standing up in a school board meeting, speaking out in response to a proposed curriculum change. It's the protester writing in a letter to the editor of the newspaper about a proposed zoning change. So these really can happen across a variety of circumstances. It's so important to have a strong anti-SLAP statute in place, of course, to deter these sorts of cases from happening in the first place, but to put guardrails in place, to put a system in place for when they do get filed, there's a way to expeditiously deal with them. The Uniform Law Commission developed this act Over the course of a number of years of study and review by 300 plus attorneys, we looked at the best of the best anti-SLAPP statutes that were already out there across the states and looked at what was working well and what was working poorly. And what you have before you today really has become the gold standard in terms of state anti-SLAPP protections. The bill does include a number of features that Mr. Mishkin already explained that make it sort of the best of the best. Again, the bill protects Marylanders in their ability to engage in public discourse, exercise their First Amendment rights, all without fear of being slapped with a frivolous lawsuit. Thank you so much for your time and attention today, and I encourage a favorable vote. Happy to take any questions.
Excellent. Thank you very much. We're going to hold to the end of the panel for questions, and then we're going to move on to Mr. Nelson. Welcome.
Thank you very much, Mr. Chairman, and thank you to the committee for the opportunity to speak here on Senate Bill 251. Tim Nelson here, counsel to the Maryland, D.C., Delaware Broadcasters Association. On behalf of MDCD's 20 or so TV stations and more than 100 radio stations, wanted to let you know that we enthusiastically support Senate Bill 251. I'll try not to be too redundant here of my other colleagues who've already spoken in favor of the bill. But suffice to say, the myriad problems that frivolous, meritless SLAPP suits cause for defendants, chilling speech, subjecting citizens and businesses and journalists to time-consuming and costly litigation have been well documented this afternoon. We've also heard a bit about the shortcomings with Maryland's current anti-SLAPP statute, particularly its hard-to-prove bad faith element and its lack of a fee-shifting provision. Fortunately, UPEPA, Senate Bill 251, and I like that acronym, properly updates the law. It would cure some of the issues with the current statute adopted more than 20 years ago. It provides more meaningful protections of free speech, including the reporting, commentary, and debate that MDCD's broadcasters champion, and it accounts for legal and society developments since the law was initially passed. In particular, as mentioned, the bill provides a comprehensive and efficient framework for the resolution of SLAPPs, most notably by eliminating the current law's bad faith provision, providing a logical burden-shifting framework employed by a court to get rid of frivolous suits early, authorizing courts to order that SLAPP plaintiffs foot the bill for the societal resources that their lawsuits drain. The provisions have been adopted, as was said by Caitlin and others, by many other jurisdictions around the nation. The bill strikes the appropriate balance, we believe, permitting meritorious lawsuits to proceed while dismissing frivolous SLAPP suits early on and hopefully causing would-be SLAPP plaintiffs to think twice before going to court. We thank Senator Love and Hedelman for sponsoring Senate Bill 251 and would also urge a favorable report out of this committee. Thanks very much. Happy to take any questions.
Excellent. Thank you very much, Mr. Nelson. All right. I think that does it for the proponents of the bill who are in the Zoom room. And then we've got a couple of people here. So we've got Ms. Snyder, and then I know Mr. Lightis is here. If you want to come on up, but go ahead, Ms. Snyder, and go ahead.
Good afternoon, Chair and members of the committee. I'm Rebecca Snyder, Executive Director of the Maryland, Delaware, D.C. Press Association. You've heard a lot of testimony about this bill, and I just wanted to bring a couple points. First, SLAPPs really do affect so many members of the public. It's not just the press. Of course, I'm committed to our members, and we don't want to have the chilling effect of the threat of SLAPP suits. You've heard from several about how long these suits grind on, years, and just the expense that you hear. That can be very damaging to a small news media organization reporting on accurate news in their community. Second, we've supported anti-SLAPP efforts, reform efforts for a number of years. This year, we decided that UPEPA was the way to go because it is the gold standard. We don't want a patchwork of bills across the country to potentially make Maryland a more attractive place for people who want to bring these kinds of suits to find a way to enter them here. So we do think that uniformity of this and the fact that Pennsylvania and Delaware have both passed it is important. And then I would just urge you to remember that Marylanders are not well protected by our current statute. That bad faith provision, you may think, well, gosh, is there a problem? There's not a lot of SLAPP suits. You've heard from people where it is really a problem, but it is very difficult to prove a SLAPP case because of that bad faith provision. This is a common sense, logical, uniform way to protect Marylanders' right to participate within issues of the public, in the public interest, and I urge a favorable report. Thank you.
Thank you very much, Ms. Snyder. Is Mr. Lightis here to testify? Welcome back.
Thank you, Mr. Chairman. I'm going to pass on my testimony. I believe that the stakeholders have adequately presented the bill.
Okay,
Speak
excellent.
in favor. Thank you.
Thank you very much. Mr. Judicial, you're up.
Yes, thank you, Mr. Chairman. Ronald Judicial, I'm a lawyer here in Annapolis. I'm testifying for the Maryland Association for Justice. I'm a former circuit court judge. I've been in practice about 50 years, just over 50 years. Don't want to repeat the points. Please take a look at our position paper we submitted. In that position paper, I've got a chart which studied the SLAPP suits from all over the country by called the Initiative. I forget what the name is. It's in the position paper. But what it reports is that Maryland's score on its current SLAPP statute is a 10 out of 100. Only 5 states have a lower score, have a score that's below 50. 37 states have a score that's 85 to 100. Maryland statute needs to be updated. It just is woefully inadequate, as you've heard from various testimony. I'm not going to go into what the ULC statute is, except to point out that from my research, 7 states have adopted it in the past 2 years, so it's very common, very timely to adopt. I was a defendant in a SLAPP suit. I reported an administrative law judge in D.C. for violating her ethical rules. She sued me. We defended it in D.C. and had a pending SLAPP statute, SLAPP action pending when my insurance company decided to settle it. I insisted on it not being a confidential settlement because I wanted to be able to talk about it if need be. I'll just point out this, that besides the bad faith the part of the law that's bad in Maryland, it provides for limited discovery, and people have talked about an expedited process of motion to dismiss for being resolved. But it also, to be pointed out, it's a balanced attorney's fee statute. If somebody files a meritless motion to dismiss, then that defendant can be liable for attorney's fees to the plaintiff if the plaintiff's suit has merit. So with that, we ask for a favorable report.
Thank you very much, Mr. Judicial. That'll conclude the testimony for the proponents of the bill. Now open it to the committee for questions. Senator McKay.
Thank you, Mr. Chair. So, Senator, thank you for bringing this bill. I couldn't get a lot of sleep last night, and I happened to be watching ESPN, and I stream it, so there's many, so it was ESPN 8, and so I was looking at the Power Slap League. That's not what we're talking about, correct?
No.
You couldn't sleep last night either, Sheriff. Is that what you're? Oh, okay, all right. So if I may, so in the bill, on page 3, line 31, and then it mentions again on page 5, line 19. It talks about an intimate threat to public health or safety. What does that mean?
So that is, as far as I understand, it is pretty standard language in our law, but I think imminent threat to public health or safety, I think the ULC, I wish Caitlin were still here to talk about that more. There she is. Caitlin, can you speak to imminent threat?
Absolutely, Senator Love.
Thank you.
Yes, yeah. So Senator, the language that you're referring to there, what our drafting committee was getting at with that is we didn't want there to be a situation that posed danger or a safety risk to the public. So think of a major pollution episode or a building that was unsafe or inhospitable. We didn't want this special motion procedure that we've developed here in the Act to allow somebody, that polluter, that building owner, to delay their ability to take action in response to that public nuisance. So those would be situations that we're trying to talk about there in that language, where we don't want somebody to file a meritless motion under this act to prevent the government for taking action to protect or to stop that public nuisance. Hopefully that answers the question, but those were the scenarios we're talking about there.
It helps, but to drill down a little bit even more, look, speech should never incite violence or anything like that, so I understand that. But my question is, so what if people claim that speech is actually the equivalent to violence? And what I mean by that is, in this wording here, who determines the threat to public health or safety? It's very subjective there. And so my concern really is, it goes right down to, could that speech, could even a prayer be deemed a threat to public health? And if anybody could speak to that, I think.
Can I start with that, and then you can come up? The judge is going to determine that. And I can't possibly see how a prayer could be deemed a threat, an imminent threat to public health or safety. If you are praying and that is all that you are doing, I can't fathom how that could be deemed an imminent threat to public health or safety. Now, if you are praying along with other conduct that could provide an imminent threat, I don't know if you're praying with a machine gun pointing at a whole bunch of folks.
You've been to my service.
Then that's a different story. But it's just unfathomable under that scenario that could be deemed an imminent threat to public health or safety. And Judge, if you wanted to.
Yeah, if I can.
Could you come to the podium, please?
Yeah.
Yeah. Yes, I thought that we do it there. I think there are two things. You need to look up at the section G right above that. And there it says that during a stay under this section, the court may, for good cause shown, may rule on, and then a motion, et cetera. So there would be a hearing to determine is, for example, a landfill or something that's causing imminent harm or threat. And the judge will stay the action according to get a resolution. The other section you pointed to talks about during an injunctive hearing. So the court always has expedited injunction hearings. As you probably know, you can get an ex parte injunction on 10 days for 10 days before, and then you have a quick, usually within 10 to 20 days, a hearing on a preliminary injunction. So if there's an imminent threat, there'd be evidence with regard to whether there is or isn't an imminent threat, whether the case should be stayed, whether an injunction should be entered. I think that's what section G says, and the other section you cited.
Okay. Just as a follow-up, let's say that judge does decide that. Is there any way that the government can bring any kind of into criminal court or anything?
Well, it's not a criminal proceeding.
Well, I understand that,
right.
But does it open up a window, crack a door, to allow then any of those actions to be brought against them by the government in criminal court, or is it completely separate?
I think what the earlier section says is that this does not apply to a governmental action, if I recall the earlier sections of the bill. And so if that's what you're saying, that if it relates to the government relating to a criminal action, it appears to me it wouldn't be applicable.
Okay. All right. Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much. So now we're going to switch over to a guest joining us virtually who is signed up in opposition, Ms. Bogley. Bogley.
You threw me. I thought you were going to ask about right to life. It means that was what I'm getting.
That's where I'm getting at.
I actually reached out to them.
I'm trying to.
Ms. Bogley, you're up. Welcome.
Thank you, Chairman Smith and committee members. I was just waiting for my Zoom to load here. I'm Laura Bogley, Executive Director of Maryland Right to Life. And once again, we respectfully urge you to preserve free speech and the integrity of this assembly by rejecting this bill and its expansion of frivolous lawsuits. Despite the change in name, the essence of this bill is the same loophole to the anti-SLAPP legislation that you've seen fit to reject year over year. This is a classic example of if it ain't broke, don't fix it. The original statute already provides equal protection to all defendants against frivolous lawsuits and invokes the guarantee of free speech for all under the First Amendment. But this bill undermines the legislative intent by depriving defendants of this affirmative defense when the government itself is the plaintiff. We believe that courts, not politicians, should interpret whether speech or action constitutes a threat to public health or safety. The Constitution and federal judicial precedent are clear that pro-life speech is protected speech. Still in Maryland, pro-life speech is routinely suppressed and pro-life citizens are threatened. Already, the General Assembly denies us the right to have pro-life legislation brought to a vote. Elderly prayer volunteers have been threatened with prosecution after they themselves have been viciously attacked and injured. And taxpayers were forced to pay $500,000 to abortion clinics for security upgrades, despite the fact that since 2022, 70% of the cases of violence investigated by the FBI have been incidents of pro-abortion violence against pro-life citizens and centers. Please allow the courts to do their job and protect all defendants who should have this affirmative defense. We respectfully urge your unfavorable report on this SLAPP expansion bill. Thank you.
Excellent. Thank you very much, Ms. Bogley. Questions from the committee? All right, seeing none, that will conclude the hearing for Senate Bill 251. We'll now move on to Senate Bill 252. Senator West.
Thank you, Mr. Chair. The Maryland General Assembly established the Maryland Legal Services Corporation in 1982 as a non-profit corporation to receive funds from the interest on lawyer trust accounts known as IOLTA program and from other income sources, including surcharges on certain court filing fees. The mission of MSLC is to ensure that low-income Marylanders have access to stable, efficient, and effective civil legal assistance through the distribution of these funds to nonprofit legal services entities. MLSC currently provides funding to 50 nonprofit grantees throughout Maryland, so the indigent people throughout the state from Garrett County down to Worcester County have access to civil legal assistance. And MLSC also administers Maryland's access to counsel in evictions program, which this committee was instrumental in setting up several years ago. Currently, the board of MLSC consists of 9 members appointed by the governor plus the executive director. This bill would simply increase the size of the board from 9 to 12. Michelle Siri is the executive director of MLSC, and she's present today to briefly explain to you why her board should be expanded.
Thank you so much, Senator. Good afternoon, Mr. Chair, members of the committee. Michelle Siri, Executive Director of MLSC. As Senator West said, I am happy to say I have a bill with no fiscal note, no opposition, and I think the whole bill file is maybe 5 pages. Since 1982, our organization has increased its budget about tenfold, and we have certainly increased the number of grantees by also about tenfold. We have not increased our board members in that time ever. And the work that the board members do, part of their fiduciary role, is to meet with the grantees to make sure that they are doing the work that they are saying that they're doing and that the funds that this state is supporting and sending to these organizations is being used appropriately. And it has just become overly burdensome for the 9 board members that we currently have. And so we are simply asking for 3 more board members. I've spoken with the governor's appointments office, and they are in support of this, and I don't think anyone's in opposition. So we would urge a favorable report on Senate Bill 252.
Excellent. Questions from the committee? All right. Thank you very much.
Thank you
both.
so much.
Good to see you both. All right. With that, that'll end the hearing for Senate Bill 252. We'll now move on to the last bill of the day, Senate Bill 16. Senator Sidnor.
All right. I don't know if it's good afternoon or good evening, but Senator Sidnor here for Senate Bill 16. Senate Bill 16 seeks to cap wage garnishments to 25% for child support obligors earning less than $40,000 per year. The goal of this bill is to improve lower-income obligors' ability to pay their support orders and to incentivize them to remain in the workforce. This provision was the highlight of the Department of Human Services Omnibus Child Support Reform Bill from last session. And this year, we are making it a standalone issue. And that point is very important because you'll see within the testimony they've now come out unfavorable against their idea that they supported last session. The 1968 Federal Consumer Credit Protection Act caps wage garnishments at 25% of disposable income for most debts, but allows up to 65% garnishment for child support and alimony obligations. The purpose of this carve-out is to ensure a legal and moral duty to provide for dependents and prevent shifting the burden of support from the individual to the government. However, that's not what we've seen happening in the real world. After taxes and a 65% garnishment, an employee making Maryland's minimum wage of $15 per hour, for example, is left with approximately $4.25 per hour, or less than $9,000 per year if working full-time to cover housing, food, and clothing. An Able Foundation report by the former commissioner for the Federal Office of Child Support Services found that the 50% to 65% withholding rate can have an unintended effect for pushing low-wage parents out of a job because the remaining paycheck is often too little to survive on. According to a 2022 review conducted by the University of Maryland School of Social Work, 65% of child support obligors in Maryland earn less than $32,000 annually. Research shows that child support is more likely to be paid if it consists of roughly 1/5 of an obligor's income, and the collection rates decline when the support orders comprise more than 30% of an obligor's incomes. When obligors leave the workforce due to unsustainable garnishments, the entire family loses access to critical financial support, and the state's tax base is reduced. Senate Bill 16 seeks to address this by following the Able Foundation's recommendation, capping the wage garnishments as 25% for parents with an annual income of 250% of the federal poverty level. For a household of one in 2026, this threshold would be about $40,000. This is in parity with other garnishment rates in Maryland and incentivizes obligors to own the responsibility of caring for their dependents while retaining enough income to survive on. As such, for that, I would ask for a favorable report on Senate Bill 16, and I turn it over to my panel.
Good afternoon, Chair Smith, the Senate Judicial Proceedings Committee. My name is Zachary Alberts. I'm the Director of Advocacy at the Center for Urban Families. We're a West Baltimore workforce and family strengthening organization that focuses on legislation that strengthens urban communities. We're here to strongly voice our support for Senate Bill 16. As you heard, it would cap the garnish rate for child support payments of low-income obligors at 25%. As an organization situated at the intersection of fatherhood and workforce development, we have worked with a countless number of parents who face an impossible choice. Stay in a low-wage job where child support garnishments leaves them unable to afford basic necessities, or work under the table to survive while paying what they can towards their support obligations. As Senator Sidnor said, Vicki Turetsky, who was the head of child support for the federal government and thus the head of child support collections, made this recommendation in 2019 to reform Maryland's child support program. Like former Commissioner Turetsky, this rightfully recognizes that an obligor is better able to meet their child support needs when they are able to sustain themselves. Low-income obligors typically experience frequent transitions in and out of formal employment due to structural barriers such as limited education, criminal records, housing stability, and lack of access to transportation. During periods of unemployment or underemployment, such as one's wages hours shifting unexpectedly, child support obligations continue to accrue based on the original order, and arrearages accumulate rapidly. When they do finally secure formal employment, they're quickly hit with a 65% garnishment rate that leaves them unable to support themselves. We have seen with many members facing this untenable situation that they quit their job, they go work on 1099s or in informal gray or black market economies where their wages don't have access to garnishment. For these reasons, because this will help actually increase child support collections through making a smart change to how we treat low-income obligors, we ask for your support and happy to answer any questions about the fiscal note or any other testimony y'all receive. Thank you.
Good afternoon, Chair, Vice Chair, and members of the Judicial Proceedings Committee. My name is DeJuan Burton. I am a resident of District 32, and I'm also the Deputy Director of Out for Justice, a grassroots organization whose mission is to engage, educate, and empower individuals impacted by the legal system. Out for Justice is also a small business employer committed to hiring from impacted communities. In that role, I have seen firsthand how excessive wage garnishments undermine employees' morale and job retention. Many of our staff are parents on child support who have experienced between 50 and 65% of their wages being garnished. When more than half of a person's income is withheld, meeting basic needs such as rent, food, transportation, and childcare become nearly impossible. As a result, our employees understandably question why they should remain employed full-time when working does not allow them to survive. This leads to disengagement, absenteeism, and too often employees leaving the workforce altogether. We invest significant time and resources recruiting, training, and supporting our staff, particularly individuals rebuilding their lives after incarceration or prolonged economic hardship, only to lose them after their second or third paycheck due to excessive wage withholding. This forces us into a costly cycle of repeated recruitment, onboarding, and training while managing staff shortages and reduced productivity. Reducing the garnishment cap to 25% for low-income workers who make up the majority of our members would significantly reduce turnover and strengthen our business. Implementing a 25% wage cap is essential to creating a stable, consistent workforce that contributes to Maryland's tax base. When low-income obligors are not overburdened, they are more likely to remain employed, allowing child support to be paid reliably through wage garnishment. For those who remain in arrears, steady employment also enables the state to recover support through state and federal tax refund intercepts. This approach supports children, strengthens families, and benefits Maryland's economy as a whole. And for this reason, we strongly support Senate Bill 16, which caps wage garnishments at 25% of disposable income for lower-income parents. And I'm happy to answer any questions regarding new hire filing process and the administrative requirements placed on employers to comply with garnishment orders. Thank you.
Good afternoon, everybody. My name is Christopher Dews, and I am with Dews & Associates, but I represent Center for Urban Families and Out for Justice. But I'm actually speaking on this issue from my own personal experience. Before I was a lobbyist in Annapolis, I used to work at the Civic Works Center for Sustainable Careers, which was run by the former Speaker Pro Tem Dana Stein. And at that work, I used to transition Baltimore City residents from non-employment and underemployment, and then 8 weeks of training, and then into environmentally friendly construction positions. So this was solar paneling, weatherizing homes, removing lead and asbestos, so they can work and build their communities and take care of their families. So we had a very strong graduation rate, something I was very proud of, very strong placement rate, something I was very, very proud of, but let's say not as strong retention rate, because after 1 to 2 months, we'd have a massive drop-off of our individuals working. And so when I was talking to them and trying to figure this issue out, it was as simple as it sounds. It was the 65% wage garnishment. Our trainees would look at us and say, look, specifically one gentleman I remember, his name was Troy, would say, Chris, thank you for the 8 weeks of training. I thank you for what you've been doing. I thank you for the opportunity to work, but this is just unsustainable. After 2 weeks of grueling work in the construction sector, he came home with $80 to take care of himself, his wife, and 2 children, and had a bit of a mental health panic, as we would say in today's terminology, over that situation. I lied to him, and I said, if you just work hard enough and stay with it, stay in the game, it's all going to work itself out. And after some time in studying the laws and realizing how this system really works, I just was incorrect. That's actually one of the types of stories that got me into working in public policy, because I realized the only way that you can make these types of changes is by taking it to Annapolis. And so what this piece of legislation does is it just puts us in parity with other debts that currently exist for lower income families for the sole purpose of ensuring that people can take care of their families. And for that, I urge a favorable report. Thank you.
Good afternoon, Mr. Chairman, members of the committee. Thank you for this opportunity. My name is Daniel Hatcher. I'm a law professor at the University of Baltimore, where I've been teaching since 2004. I teach first-year contracts. If anybody went to law school and hated contracts, you can vent at me about it. I also teach a clinic where law students learn by representing low-income clients. I represent children, parents, custodial parents, non-custodial parents. In my prior work as a senior staff attorney with the Children's Defense Fund, I was also a legal aid attorney where I represented both custodial parents and non-custodial parents and children in the child welfare system. So I've been on all sides of this issue, and my research over the past 20 years leads me to strongly to support this bill. It's crucial, it's common sense, it helps everybody. It'll benefit children and custodial parents through increased payments, increased connections with the non-custodial parent when appropriate. The bill will benefit non-custodial parents by improving their ability, right, to pay. Most want to pay, right? But they also have to live. You know, you have to eat, you know, occasionally while you're trying to pay your child support. It will, as you already heard, benefit businesses, right, throughout Maryland by not losing their employees who desperately want to work, right? It will benefit the child support agency through those increased collections. The numbers will look better for the agency, which will increase their Title 40 incentive payments, which is part of the reason likely why the agency invited me to testify along in support with them, right next to the secretary, strongly in support of this provision last year. The bill will benefit all of us, right? Because as low-income parents are able to keep working, right, are able to live while they pay their child support, it helps our communities in which we all live. You've already heard much more important testimony from everybody else. I just want to give a shout out, compliment. I've worked with a lot of nonprofits over the years, and I'm so impressed with the Center for Urban Families and Out for Justice, with everybody working there and everybody who's here today. So I couldn't be more impressed with them. Thank you.
All right, thank you very much, Professor. We're going to turn it over to the committee for questions. Senator Charles has a question.
Thank you, Chair. So I have three questions for this panel. My first question is on just specifics. Is this cap on earning withholdings, or is it when a cap when orders are actually set? So for instance, if child support, if the courts say you have to pay $1,000 in child support, that $1,000 is more than 25%, the judge can't actually make that child support award. Or is it, if they do set $1,000, they can only take $250 of that $1,000?
It's a good question, and I know there were some comments filed by the MSBA, right? And it's really sort of apples or oranges between garnishments, right, and setting the orders, right? So this bill, the language of this bill, does not affect actual income, right, that is considered as part of the process in setting a child support order. It only applies to garnishments. Garnishments only kick in when there are wages, right? And that would set the cap at 25% on those wages only for low-income obligors. If there are other sources of income that aren't wages, right, those would not be subject to this cap, right? There might be, like, and there are other ways where they can collect payments, such as through tax intercepts. This doesn't affect that, right? There might be other ways where they can attach a bank account. This doesn't affect that.
So I don't know if I got the answer on that. So is set on, the cap is set on the earnings withholdings for child support, or it's set on when the order is set?
It's set on the...
It's on $1,000. Is it $250?
On earnings. after taxes. So that's the disposable earnings.
And this is happening with the actual courts. This is with the courts and not with child support enforcement?
You mean in terms of who would determine
Because
it?
there's two different folks that handle this, right?
Right. The court set the orders.
If the court set the order, child support enforcement, they are responsible for collecting the child support.
That's right.
And then there are laws in place that they can't take a certain amount of money. So with that garnishment, so if you got an IWO income withholding order that's set in place, they can only take a certain amount of money based off of what that rule may be. So what I'm looking for is this happening in the courts, or is this happening once the order is set and they can only take a certain amount of money?
Once the order is set, right? And then it's actually happening with the employers, right? You know, like, because then the garnishments go to the employers, and there's already caps under the federal law of 65, 55, 50, I missed one, or 60, right?
Yeah.
This would set a different cap for low-income obligors, and there would be no additional burden on the employers, but it would be the same process.
Only thing is, I support you guys 100%, and I love all the work that you're doing. But I do realize, what happens with this, if they're only going to take the $250 of that $1,000, we set that cap at 25%, that's $750 that's still going to be remaining out there, that's going to be going into arrears, that's going to be accumulating over time, that's going to put that person further and further into debt versus, and I get it, they will be taking that money, but now you're talking about your vehicle, your license being suspended, all of these other nuances that come with building up arrears.
Right.
And if your arrears hit more than a certain percentage of of what you owe every month, then you now find yourself in an even deeper predicament. So I like what you guys are doing. I don't know if we're doing it the right way with this bill or not. I'm just really reading into it. But I want you guys to win because you're fighting for the little guy.
I'm going to turn that over to
Yeah, thanks. That's a great question. So I'd say a couple of things there. One is that Maryland's made a lot of progress the last couple of years in right-sizing the initial child support order so that when someone is low income, that it's not a giant order compared to what their income's set at, right? So we already do a decent job with low-income people saying, let's not have a crazy high order the person can't afford. And next year will be another review of the quadrennial guidelines that helps us determine these. So it's important to get that right as well. But where we also see a problem is when orders are set, they're set at a reasonable level, but because people are dipping in and out of employment, they're getting those garnishment rates. Or you'll hear from another witness today who the child support order petition happened 8 months before he started working. The second the child support order was heard in the court and they set it, he started off $10,000 in arrears at that moment, and his almost entire paycheck was garnished. And so we're really looking at these two flows that you're describing in parallel. One, we need to relook at in next year. Every 4 years, we look at, do the courts set responsible and reasonable orders, but there's all these secondary and tertiary issues around wage withholding that do drive people out of the workforce. So agreed with your overall point. The most important thing is that the court is setting a correct, affordable order. Right now, our courts are not in a place where they can month to month modify child support orders as people's hours change, they get fired, they jump from one job to another.
Okay. Now, are you guys aware of the MSBA testimony?
We are,
yes.
I think, Dan, you were going to take that one.
Yeah, sorry, that's what I was starting to talk about a little bit before. And we're happy to chat with folks at the MSBA further about this. But the issues raised in their testimony are really sort of apples and oranges. They raise some questions about language that's used for establishing orders in Maryland. There's already language in the Maryland statutes that all sorts of income can be looked at, right, actual income. This bill does not limit that at all, right, for order establishment. This bill only applies to, again, the garnishments, right? And the reason why the specific language and the definition is in this bill of disposable earnings is that's federal law, right, under the Title 4D system, right, which governs the child support system in Maryland and every state, right, and also the federal consumer protection law, right, which again implies we have to align ourselves with federal law, right? But that would only apply to garnishments when people are working, right? Like, so wages, so that disposable earnings, that cap wouldn't apply to, again, other types of income, right? Those wouldn't be subject to the 25% cap.
And my last question for you guys is about the fiscal note. Can any one of you guys kind of speak to the fiscal note on this?
Sure. So as was already testified, that we introduced language that mirrored DHS's language from last year. In our mind, DHS has given us some feedback that maybe there's a difference of opinion that we're still working through. Either way, I think they've raised a few issues that we recognize as real issues, namely that before the driver's license suspension legislation that was passed last session, they don't necessarily know the income for every single obligor in Maryland in CSMS, their computer system. They know that information since October 1st of 2025. And so we've reached some sort of high-level ideas around introducing some friendly amendments that allow us to say, moving forward, for any child support guideline or any child support order established after 10/1/25, where DHS has the income information from the child support order in DHS, they will know right off the bat, right, it's a 1 or a 0, is this person above $40,000 a year? If they are above $40,000 a year, nothing changes. If they're below, we would generate an IWO, a wage withholding order, that has an addendum that says this person should not be garnished at more than 25%. And so that and a few other things will remove the fiscal notes staff requirements, right? And it becomes just very simple programming, right? There's a field in the child support system that says this person makes $40,000 or $70,000 a year. That's a 1. That's above. Send the normal automated letter. If it's below, send the new letter that says don't garnish at more than 25%. And so with that, and once we flesh out exactly what those amendments should look like with them, we think the fiscal note should drop precipitously because it's just some basic computer programming.
I'd like to add some amendments with you guys too.
Okay,
so
yeah,
let's
that'd be
work
great.
on that together.
Excellent. All right. Thank you very much for this. I know you have another more panelists coming up. I think we have, so April Hamilton is joining us remotely. Is anyone else in the room here to testify in favor? Come on up. We're going to have Ms. Hamilton, and then we'll hear from the rest of the panel.
First of all, I'd like to thank you for allowing me the opportunity to testify today in support of this bill. I'm April Hamilton. I'm a solo mother of 2 children living in District 8. I am an obligor for one child and a recipient for the other. This gives me a unique perspective on how the system actually functions for families like mine. Today, my arrears are around $18,000 and my wages have been garnished and my taxes have been garnished for almost the past decade. I'd like to express deep gratitude to the committee for passing last year's license suspension bill. Because of that bill, I was able to regain the privilege of having my driver's license. And while that reform has helped improve my situation, the wage garnishment system still remains structured to make it nearly impossible to get ahead. For years, I worked 6 days a week as a server, often 12-hour shifts or more. And I would sit at work and I would cry, trying to think of how to make my bills and my budget work, how to keep the apartment that I had worked so hard to get, how to keep the car that I'd worked so hard to get, and how I was going to feed myself after all of that. At that time, I was making roughly about $1,600 a month, and my child support payment was about $500. That's roughly 1/3 of what I was making at the time. The budgets said that my rent should be my largest expense, and my child support fell right behind that. But when your rent and your child support are about 1/3, it doesn't leave you with much left at the end. The harder I worked, the deeper I fell. My arrears continued to grow, and it felt like there weren't enough hours in the day to get out from under the debt. I wasn't discouraged, though. Even when I didn't have a car, I went to work. I walked 8 miles a day to get there. After basic expenses, I could barely afford food. I survive financially by the support of my family, but I have constant worry about what's going to happen when they're gone and not being able to reach independence, let alone seek legal counsel to address issues like custody. Under the current wage garnishment structure, there's no real path out. When the levels are too high, the arrears sometimes grow to insurmountable levels instead of being resolved. I want to be financially independent and have hours in the day to pursue further education and a better job and stable income for my family. I want to work. I want to take care of my kid. this bill would make that happen. Thank you.
Thank you very much, Ms. Hamilton. All right, we're going to hear from the rest of our panelists and then open up for the final round of questions.
Good afternoon, Senators. My name is Chris Seymour. I'm a resident of District 43. I'm here to speak to you about the support of Senate Bill 16. I want to be clear about something that matters deep to me. I want to support my children. That has never been in question. I love them. I care about their future. And I believe providing for them is part of my purpose as a father. At the same time, I'm struggling under a system that has become overwhelming to the point where it's affecting my ability to live, function, move forward in a healthy way right now. The financial burden of wage garnishment leaves me consistently behind, anxious, and feeling trapped. I'm working, I'm trying, but the pressure is so heavy, it feels like no matter how hard I push, I cannot catch my breath. I'm not asking to walk away from my responsibilities. I'm just asking for a realistic path that allows me to support my children without being crushed in the process. 5 years ago, I was badly injured in a workplace accident, overprescribed painkillers. Years of struggling with consequences of addiction led me to more than $50K in child support in arrears. At my second successful attempt at rehab and competing in a workforce program, I'm finally able to work a conventional 9-to-5. I earn $19.50 an hour as a bank teller. A 65% garnishment rate means that I'll be left with $5.45 an hour, about $750 per month, to pay rent, buy groceries, pay for transportation to and from work. Luckily for me, I'm able to live with my mom right now, so I can barely scrape by. But if she ever changed her mind, I'm afraid I'll be forced to decide between keeping a job allowing me to pay child support or working or having to work underneath the table and pay when I can. Supporting my children should not mean losing myself entirely. I'm asking for understanding, I'm asking for fairness, and opportunity to move forward in a way that benefits everyone around, including my kids. Thank you.
Good afternoon, Mr. Chair, members. So I'm a father of an 8-year-old son. My journey through this child support system has been nothing but a spiral into financial ruin. It starts with the court order that I had to wait 6 months on. Once that court order was signed, I instantly gained a debt of $8,000, which automatically puts me in arrears for my child support before I was even able to make my first payment. So imagine I have a job, full-time job, I have a mortgage. My mortgage is $1,300. Because of the arrears and the added monthly payment for my child support, I now have a $1,400 bill instantly. Lost my license same day, which as a result, I lost my job. So now I can't work to pay anything because of the wage garnishments and arrears. So the downward spiral has been 6 years. Bouncing from job to job, trying to find somewhere to live because I can no longer afford to live, right? So now I'm working full-time, Baltimore City employee, making about $17 an hour. My checks weekly, because of the wage garnishments, are about $250, right? And I'm still responsible for paying that monthly $680 payment for child support. It's near impossible, you know? I've lost everything financially, and because of that, I'm also losing time as a parent. My son is losing time with me, and that's something that I can't get back, and it's making it difficult, not only for myself, but for others who are in the system as well. So please consider not only the financial burden, but also the burden on our children as well. Thank you for your time.
I just want to tell you guys so much for coming out here, and April, for you showing up as well. You know, I've been in this very, very same position. Everybody knows I'm the resident expert on child support and custody issues because I've been through it. I've seen the nasty, the ugly. You know, I was making $98,000 a year, and they set me with a $3,600 child support payment every month. I was paying more than NFL players pay. And $3,600, that's 44% of my income. I couldn't even afford to pay my mortgage. I had my vehicle repossessed, almost foreclosed on my house. And like you, April, and like you guys, thankful for a family support system. Had I not had my mother, who allowed me to move into her house, I would have lost everything. I would not have had anything. And I still had time with my children. So my kids would have been with me homeless, and had they been homeless, we would have been in court and they'd have been taking my kids away from me because I didn't have a house to have them in. So, you know, all of these things, they go to your mental health and how you operate as an individual. And I ended up losing my job. That job that was paying me the $98,000, I lost my job. They said, Nick, you know, right, you're not yourself right now, and it's not beneficial to the customer. So I ended up losing my job. Unemployment's only $1,800 a month. That's the max in the state of Maryland, $1,800. But then they hit me for $1,200 a month in child support. $1,200 out of $1,800 leave me with $600 a month to be able to take care of my family. And because the vehicle my vehicle had gotten repossessed, and I had a good friend who had a car over in Southeast DC in front of his house for sale. The car was a 2,000 Mazda Protege. Had a bullet hole in the back of it. I put a Obama sticker on the back of it to get it through inspection. And had to get that car through inspection. It was a lot to go through all of those things. That car squealed, but thankfully I had friends that were mechanics. They taught me. I started using YouTube, learning how to work on cars and doing all of these things. And it was then when I realized how broken this system was. And it made me run for office. While I was looking for jobs, I started knocking on doors and saying, I gotta come to Annapolis to change this. Some of these judges don't know what the decisions that they're making, the impacts it has on these families. The Office of Child Support Enforcement, they're raggedy as hell. You go in there, they're allowing people to have conversations in public spaces without blocking folks off. You go into Virginia, they got a private room for you to have a discussion. The embarrassment, all of those things. So I understand everything that every single one of you guys are going through. And it takes a lot of guts and gumption to come up here and tell your story. And so don't give up fighting. You know, continuously take care of your kids. My kids come up here all the time. They run around. Everybody have seen my children up here. But take care of your babies. Keep fighting for your kids. And we're going to work through the system. We're going to change some of these raggedy-ass laws that this state has. We're going to work on it.
Well, Senator, thank you. Thank you. Honestly, look, that's one of the beautiful things about our legislature, the citizen legislature. You've got people from all backgrounds and experiences and points of expertise, and so obviously your perspective is invaluable to this discussion. And I want to thank everyone that came up, from the panel. I know you spent all day here with us. Thank you for hanging in here with us to offer your perspective. And I always talk about this committee. We've got such responsibility from. I talk about this whether and how and when you can see your kids, and all the way through to, what you get if you commit a serious crime, to some of the immigration stuff we're talking to. So it just shows you how the work we do here touches everyone in a very personal way. So thank you all for hanging in here today, and thank you, Senator, and thank you, Senator, thank you, panelists. If there are no further questions, just say thank you, and we'll then change over to there's one witness here signed up. Thank you. In opposition. Thank you all, though. Thank you. All right. Brendan Madden, you're up.
Good afternoon, Chair Smith, members of the committee. My name is Brendan Madden. I'm here on behalf of the Family Law Section Council of the MSBA to express our opposition to Senate Bill 16. Maryland has a well-established and robust child support scheme, and it's based around the mandatory child support guidelines. And and the authority that is placed in the judiciary to establish child support. This bill would sidestep that entire body of law and the adjudicative process that results in it by imposing a downstream cap on garnishments, which is the collection mechanism for child support awards. It's going to be calculating that cap, basing it on a completely different standard than what the child support award is based on in the first place, actual income under 12201 of the family law article versus disposable earnings, a much more narrow definition. One of the witnesses said it will put us in parity with the other debts under the corresponding federal laws. Well, that actually means that we would be in direct derogation of that federal statute, the the credit, whatever, I'm sorry, the CCPA, which specifically authorizes garnishment for child support and spousal support at this increased rate of 50 to 65%, which is double the standard of 25%. And if we do that, we are risking Maryland's compliance with the federal regulations, the federal laws that allow us to receive Title 4D funding. And there's so many different examples of amendments and changes to this law that have been done to maintain that compliance. To the extent that there is a need, and I'm not saying there isn't, for greater relief for low-income obligors, the appropriate way to address it is not through changing the downstream garnishment mechanism. It's to go and look at the child support laws themselves. We have some provisions in place already, the self-support reserve, but garnishment is not the appropriate way to do it. So for these reasons, the Section Council would urge an unfavorable report on SB 16.
Excellent. Thank you very much. And we have, I think Senator Charles has a question.
You can't run away that fast.
Wouldn't dream of it.
All right. Now, are you aware that this policy recommendation, this is from the former head of the Child Support Administration?
I do, but she's not the head of the Child Support Administration now. And so I understand there's a degree of respect that goes with the opinion of someone who's been in that position. But the concern that we should have is what happens with the application and enforcement of our statutes now. And whatever the recommendation of a former federal official might be, I don't think it should be dispositive of our state policy and our state policy vis-a-vis whatever is happening in the federal government.
Okay. I know I gave out my whole story, and I hate to be brash or too intense. Do you have children?
I do not.
You don't? What would you do if you were put in a predicament where you had to deal with something like this? And the current paycheck that you bring in right now, they're taking 44% of your paycheck. How would you be able to operate as a man right now? Have 44% of your paycheck taken away before you even pay taxes.
I can't speak to the other than I am a family law practitioner. I mean, I understand, and I heard the laughter, and I'm not here to be the big champion of child support in Maryland. I'm the Section Council and me personally, we have our issues, as everyone does, with the laws that are on the books, the way that they are enforced, what the judges do in court. But I don't think people
have a problem with child support itself, because everybody wants to take care of their children. Everybody wants to make sure their children have the necessities that they need. But there becomes a point when 44% before taxes, you're not left with much to be able to even take care of your children when you have them, let alone take care of yourself.
And I think part of the problem with tying it to garnishment is when we're saying, well, we're looking at income differently with this cap on the garnishment than we are when we're talking about what is someone paying for supposed to pay for child support in the first place. Because there's a lot of different income that goes into that child support number that is beyond just employment income.
Yeah.
And it is money that could easily be coming in, this maybe not the most accessible example. I was just thinking in the gallery of, say I'm a PhD student, I'm getting a stipend of $2,000 a month. That's my employment income. But say I worked beforehand and I've got a bank account that I'm able to draw on. Say I've got parents who are supporting me. That's income that is calculated for child support, but under this garnishment, statute, it would not be counted. Someone might qualify for this lower rate even though they're fully supporting. And it's something that would be caught in the court, but not caught downstream by the Child Support Administration or whoever is implementing the garnishment. So again, I think it's just a matter of if it is an admirable, certainly, and a worthy issue to address, but garnishment is a blunt mechanism to do it. And perhaps that's one of the reasons that's the focus here, because it's hard to, fudge the numbers when you're just looking at the income.
But they do have IWOs, right? Well, I've had IWOs. My kids are 12 at this point since they were born. Since my son was born, I had an IWO, income withholding order. And so even when I was on unemployment, they were taking, I had an IWO on the unemployment checks. That's what made them take the $1,200 out of the 18. Like, there should be something where you can put somebody in position. They left me with $600.
And there are mechanisms, my understanding, under the laws we have in place. I mentioned the self-support reserve, which up to a certain threshold of combined income adjusts the guideline number to, at least in theory, ensure that the obligor has enough money to live on despite their child support obligation. And again, I'm not here to offer any particular recommendation, certainly not on behalf of the MSBA, but the thought would be, rather than attack garnishment, which is the collection mechanism, if there's an issue with a child support award that is too high and does not allow someone to live, then the remedy should be at the point of the original award, not at the collection downstream. And you raised a point earlier as to an arrearage. This bill, when you attack garnishment specifically, it leaves out, you mentioned, okay, you have a $1,000 award, you're only paying $250 a month. That's a $750 arrearage that you're accruing month after month after month. You're capped with what you're paying in real time, but eventually it comes due. So it solves one problem to an extent, but leaves many others that eventually, it's not a complete solution, certainly.
I would love to work with you and the rest of these guys so we can come up with a proper solution.
Thank you.
Thank you. And thanks for coming and testifying. Would you agree that it's true that there's already a cap on child support garnishments that is separate from the order process?
Well, there's, under the federal law, it can't exceed 50 to 65, and that depends on whether there are other child support obligations existing and other dependents in the obligor's home. But as far as Maryland law is concerned, I believe the current statute says the amount of the earnings withholding, and this is 10-122 currently, the amount of the earnings withholding shall be enough to pay the support and any arrearage included in the payments required by the support order.
Are you saying that there's a cap, or are you not saying there's a cap?
I believe the only, as far as my understanding, the only hard cap is the one imposed by the federal law of 50 to 65%.
Would you agree that this bill only affects W-2 income?
I'm not sure if that's the case, just based on what the definition of 10-101. I don't believe in the MSBA's written testimony. I knew at the time that earnings is defined under 10-101. Disposable earnings is new, but that includes more than just, it would seem more than just W-2 income, annuities, pensions, Social Security, workers' comp, unemployment, still far more narrow than what you look at for actual income for child support, though.
Gotcha. Again, I do thank you for coming down, and because the State Bar Association has decided to speak on this, I do hope that you can help us come to some resolution, because as my colleague said, we want to make certain that people are able to work and support their families. We're not trying to drive people out of the workforce. So thank you.
Thank you, Mr. Chair. Thank you for coming down and testifying, and I want to thank all of those who spoke today, including my colleague. This is a very difficult issue. One question I have that maybe you can help me understand, when the child support amount is decided, what goes into that factor? It's not something that a judge just pulls out of the air. What goes into that?
So if we're doing a guideline calculation, which anyone affected by this bill would be, the court has to determine the actual income for both parties. Then there's an adjusted actual income which subtracts certain expenses, and then looks at whether it's, you have a sole guideline, depending on overnights, right? The formula will vary. You plug in each party's actual income as the court has determined, monthly income, and add in there's other expenses that are included in the actual formula. Extraordinary medical expenses, health insurance, and several others. Some aren't, like daycare we hear a lot about, tuition can be considered, but it's discretionary. And from there, they just run the calculation and it spits out a number. And at that stage, once they get the recommended guideline amount, there's a rebuttable presumption that that's correct, but the court does have discretion to deviate from the strict guideline upwards or downwards for various reasons, and it has to state those on the record. And I believe there is, and I'm not sure if it's necessarily in a statute or it is just developed through case law, one of those deviations can be for a purpose like this, where yes, you get this child support award against you, but you're the obligor, you won't be able to pay it. You can ask the court in that moment, I will not be able to survive if I have to do this. Now, you'd have to prove that and convince the judge, but they could set the amount of the actual child support obligation lower based on, some of the issues that are being raised in support of this bill. And again, that would operate at the initial level of the child support award rather than downstream. And I think importantly, that would also give the opposing party an opportunity to be heard, which would not happen if it's just this, all right, well, OCSC is looking at whatever, the Department of Labor, whatever information someone has about income from the last year, okay, he's capped. No one gets, the opposing party gets a reduced check and has no say. I went a little beyond your question, I apologize, but.
Thank you for that. That was helpful. I think my question was more, and if I heard you correctly, it's the cost of raising that child, and then you also balance in the income of both the parents.
Well, it's based on whatever the combined income is, the court spits out, there's a total support amount, and then it gets divided between the parties based on their income share.
But that total support amount, it's not just a random number,
No.
right? Isn't it actually based on what it costs to raise that child?
Well, it's based on some estimates.
Well, of course,
yes,
you're not going to know, to the dime.
Yeah.
Right.
It's some, estimated amount that is an appropriate amount of support for that child. Yes.
Okay, thank you.
All right, further questions from the committee? Mr. Madden, thank you very much.
Thank you.
All right, have a good one. Thanks for hanging in there with us. With that, that'll conclude the testimony and the hearings for the day. This is a long one.